all the documents that has been filed with court, my lord. But all the discovered documents are not on e-justice, are part of the trial bundle. They will obviously only come part of the court record once they are handed up and admitted as exhibits. So all the discovered documents, my lord, will be in the trial bundle.
The trial bundle is the one that is up here?
Yes, okay. The physical copy.
Have you numbered those files?
Yes.
Okay, let's move on. The documents that we wanted to present to the witness are in which volume?
The volume 4 of 16. The one on top. Yes. That one. No, just the file itself.
No, just the volume. Volume 4 of 16?
Yes, that one. The one you have in your
No. You see, it's not that I'm admitting the whole file. He will refer me to the documents, and then he will do what is necessary to be done for the documents to be. Yeah.
May I proceed, ma'am?
Yes, you must.
Mr. Amupanda, you have that document before you. Can you go to page 1138? Okay, can you identify what document is that? Sorry, let me just wait for the court to get there.
Yes.
Can you identify what document is that?
This is the document I got from the officials when they confiscated and burned my meat. The same document that they asked me to sign, and they signed also after that exercise.
Can you just read the way it starts with declaration of confiscated?
It says, I, Mr. Job Amupanda, ID number 870828000703, with vehicle registration number 870087W, type of vehicle Toyota, date 17/05/2021, hereby agree that the below product have been confiscated during the searching process at Oshivelo checkpoint. List of confiscated products: plastic of raw meat.
And you indicated you signed on that document. Which one of you is your signature?
Is that one written signature, owner of confiscated product?
Okay. And what is the next to that TVS?
So those are it's the official. It's them who produced that document to me.
Okay. My lord, this document has been discovered. May it be received and admitted as exhibit. Should we use A? Is only this one and the next one.
Okay.
Yes.
All right, then it's exhibit A.
As the court pleases.
But I want to alert you.
Yes.
That these documents, as you correctly pointed out,
yes,
are not on the court file. Now, I can't recall whether I did put it in the pre-trial, but what I normally put in the pre-trial is that the legal practitioner who tenders into through whom documentary evidence is tendered into evidence must, at the end of the day, upload those documents that were tendered into evidence on a memory stick, mark it in accordance with the allocation, and hand it to my assistant registrar for them to upload it on the e-justice system.
Ask the court, please. We will much oblige, my lord. Mr. Amupanda, the next document I want you to look at, it's on page 972. It's the same bundle, my lord, 972.
Yes, I'm there.
Can you just identify to court as to what document is that?
This is a document that is a report that was produced by the consortium, commissioned by government, and led by Mr. Dirk Conradi, whom we had subpoenaed as a lead consultant in that project.
Okay, what was that project? Can you just read on the...
We object to the examination on this document. Firstly, Your Lordship, on more than one occasion in the course of preparing this case for trial, indicated to the parties that no surprises would be tolerated. There would be no ambush of other parties. There is absolutely no indication in the witness statement of Mr. Amupanda that they're going to refer to this document. We don't know where it comes from, why it should be admissible, why it's relevant, what are they going to use it for in their case, is it relevant? There's no summary of expert evidence given in respect of this document. It's obviously hearsay, more than once hearsay, and we object to this document.
My Lord, we similarly object. May I elaborate? The court bundle consists of 1,762 pages. The trial bundle, from which this document is now taken, consists of 6,837 pages. There are an additional 3,000 pages discovered in relation to confiscation in similar circumstances from other people. This report itself, your Lordship may accept, consists of 165 pages. Now, it is discovered, yes, and that would make it permissible on that level, but your Lordship would recall that the witness statements were staggered, and when we dealt with our witness statements, we obviously had regard to the plaintiff's witness statement. Now, we are now at the point of being asked for the document to be admitted. So 165 pages will go in respect of which I have not dealt with in our witness statements or had the opportunity. It's very similar, so for you want to rely. I will then look at it duringly, my Lord. I respectfully submit should not be permissible. Please.
My Lord, as both counsel correctly pointed out, this document was discovered. It was in fact in addition to the document that these documents cannot be produced. It was discovered before witness statements were drafted, And that is the purpose of discovery. If there is anything to say this document should not come into the sphere of the court, that opportunity has been presented to the parties in the new dispensation of the case management rules, and that if you if you do not object to the document when it is discovered in terms of Rule 28, you can't come, that dispensation has been gotten away with the new case management rules, my lord, and you cannot at this stage object to the admission of the document.
I'm sure we read Rule 28 differently. My understanding of Rule 28 is that a document
Yes.
which is not discovered may not be used at the trial.
That's correct.
And yesterday, I asked you a question.
Yes.
How does one tender documentary evidence into the record?
Yes.
It's through the testimony of the witness.
That's correct.
And yesterday I asked you also, what is the effect of Rule 92? Rule 92 requires a witness to prepare a witness statement of all its testimony that it will deliver at the trial.
Yes.
In Mr. Amupanda's testimony, no reference whatsoever is made about the report, the consultancy, the final report on the consultancy to investigate the implications of a total removal of the veterinary cordon fence. There's no evidence to that effect. No intimation has been given in the witness statement, in the testimony, that that document will be relied on. How do you expect your opponents to deal with it?
If I may just get instructions.
And remember,
Yes.
there are two bases of objections.
Yes.
One, that it is hearsay, because Mr. Amupanda is not the author of this document, and no intimation has been given whether the author of the document will come to testify on the document.
Yes.
So it's two grounds.
Yes. The intimation, that is correct, that the author is not coming to testify. The author of the document, the lead one is Mr. Conradi, who obviously the subpoena is void, cannot testify to it. And I actually just seek, my lord, even 10 minutes I have seen authority on the hearsay part. All those issues.
No, you see, the hearsay part, let me just assist you.
Yes.
The hearsay part is that it all depends on the purpose for which the document is.
Is that once the document is discovered?
I'm not talking about Rule 28. I am talking about, and I asked you yesterday.
Yes.
How does one tender documentary evidence into trial? You just don't come because you have documents. You have discovered the documents. Those documents must be handed up. You don't. You testify to the document. You identify the document. You verify it, and then it's only then that it is admitted.
Yes.
Not because you have discovered the document.
Yes. It's also on that basis, my lord. I just wanted, the back of my mind, I have authority where I just want to confirm that once it can be used at trial by the witness while they are still under oath.
You're missing the point. Nobody said Mr. Amupanda cannot use the document. Nobody said that.
Okay.
The point is, Mr. Amupanda did not testify to the document. Your colleagues have not been alerted that Mr. Amupanda will make reference to the document and that he'll testify to it. That's the objection.
Okay.
Not that about its discovery. It's an ambush. It's ambush.
that is the authority actually I want to, at the back of that, the document, it cannot, its admission at this stage, even though not referred to in the witness statement, cannot be objected to the admission of the document into evidence.
What I'm asking you is,
Yes.
so are you telling me any witness can come, have a list of documents to which they did not testify, and because they have been discovered, I must just admit them?
No, he must still testify to it. He's still under oath, my lord. He must still testify. It's
Testify where? If the witness
still testifying, my lord.
No. Remember, Mr. Amupanda read his witness statement into the record. You indicated that you are going to just the documents that he referred to in his witness statement. Those are the ones that you want to hand up. And that's what the opportunity I gave you.
Yes. My lord, my only request is really to say if the court will allow, so that I give that authority. If the court declines that, those are our positions that
why are you litigating the way you are litigating? Every time you need something, I must adjourn for you to go and look at the authority. Why did you come to court unprepared?
My lord, it's not that I'm unprepared.
Yes.
The Lord has been making too many statements about my person, but it's not that it's not
I'm
my
not making
personal
statements. I'm
matter.
pointing out facts to you. I'm not making statements.
But
if
my
I'm
lord,
wrong on a fact, tell me you are lying.
To say I'm not prepared, my lord, it's a point that is raised here, and I'm saying,
No.
my lord, I have authority at the back of my
If
mind.
you have it, then refer me to the authority. Now you are asking me to stand down for you to look for the authority. That's what I'm referring to, that you are not prepared. It's a fact I'm stating. And if I'm wrong on my fact, point me, give me an alternative fact which disproves the fact that I'm putting to you.
Yes, my lord, I don't need to go to do that.
No, you have
But
said
there's
I'm
a-
making statements about you.
Yes, my lord, since yesterday, I'm representing the plaintiff, my lord.
Then, you see, that's why I'm saying you are representing a client. You
Yes.
come to court prepared and to continue.
Yes, and
The evidence of what has happened, it was testimony that you were totally unprepared.
No, my lord, that I don't agree with. But my
Okay, yes,
submission-
let me give, I'm
let's-
going to
let's-
give,
let's
I'm going,
proceed,
not
my
going to be
lord.
distracted. I'm going to stand down, give you the 10 minutes. I'm not going to fall into that trap. I'm going to give you the 10 minutes, prepare, and we come back. What time is it?
As the court pleases, my lord.
Thank you.
Yeah, again. 1:15. Yes, Dr. Tinda.
Thank you, my lord, for the indulgence. I have gotten some authority. Can hand up a copy in response to the objection, my lord. My lord, that authority is in the matter of Jacobs. That first page, my lord, the order, the second order, the respondent is ordered to file witness statements that do not refer to the bundle of annexure on or before 30. It's a case where the witness filed a witness statement and attached annexures, or referred and attached annexure to that witness statement. And importantly, my lord, page 8, paragraph 23 of that judgment, page 8, paragraph 23, the court held, my lord, the rules governing witness statements and their use at trial, Rule 92 and 93, do not address the issue of annexing exhibits to a witness statement or the filing of bundle of annexure. It then, my lord, continued that rule to refer to Rule 28.1, where the court with emphasis underlined that a party must, without the necessity of being requested by any other party to make discovery, identify and describe all documents, analogs or digital recordings that are relevant to the matter in question, and in that respect, in respect of which no privilege may be claimed, and further identify and describe all documents that the party intends or expects to introduce at the trial. The other important paragraph, my lord, I want to refer to, if I may, is from paragraph 25 as well, where the court said, referred to Annexure 4, Discovery Affidavit and its purpose, that a column titled Trial Document, a footnote thereto reads, reference to trial documents refers to. It is worth noting that the word identify that is relied upon by the respondent in filing the bundles of annexes, Rule 20, but that's not important. There is the important one is paragraph 29, my lord, with reference to the case of Central Gas Namibia CC, where they say, in the context of the matter, the word identifier as used in Rule 28, Practice Directive 18, in the practice note issued by the Judge President on 21 May 2013, does not envisage the attaching, or it is only the witness statement that must be filed without being accompanied by intended exhibit, and the exhibit may only be shown to the court and be used by a party if it has been admitted into evidence. In the absence of that, it cannot be shown to the court or referred. And another judgment, my lord, is a judgment of Nedbank.
What is this judgment? What is it that you're saying it's conveying to me and telling me?
This witness filed a witness statement, referred to annexure, and attached them, and was ordered to file a witness statement without such annexures by the court, and not referring, because Rule 92 does not say the witness must, once the documents are discovered, Rule 92 does not say those discovered documents must be stated in the witness statement. And the Nedbank Namibia versus Kriye judgment that, my lord, I unfortunately didn't print a copy of this one. It's also to the effect that if a party fails to dispute a document in the case management report, that document will be admitted.
I said to you, that is not my issue, and that's not my concern.
Yes.
How do I dispute a document which I don't know whether it will be used or not? How do I dispute it? You want me to be a prophet to know in advance that Mr. X will use document, so let me object to that document.
No.
I know that Ntinda. The cracks and the crisps issue here, it's about fairness. It's about fairness. How do you expect? Remember, you file a witness statement. The other party, and I stagger it. You file 1 week, your opponent files after another week to prepare his or her testimony also, and to answer partly to your testimony. Now, if in your testimony you don't forewarn them, how do you expect them to prepare themselves to answer to that document, or even to ask questions in cross-examination about that document?
Management to deal with all.
How do I deal with a document that I don't know that it will be used? That's a question I'm asking you.
My Lord, Rule 28, Sub-Rule 1 states,
All right.
if I may refer to that rule, a party must, without the necessity of being requested by any other party to make discovery, identify and describe all documents, analogs or digital recording that are relevant to the matter in question and are proportionate to the needs of the case, and in respect of which no privilege may be claimed, and further identify and describe all documents that the party intends or expect to introduce at the trial. Then that same rule, my Lord, says once that party does that, like the plaintiff did in this case, if any other party objects to that document that, look, you cannot use this document because it amounts to expert evidence, or you cannot use this document for this or that reason, then Rule 28, Sub-Rule 7, my Lord, give that party an opportunity to say, when in the case management report, to say that document you have discovered, I have a problem with it, and you cannot use it at trial, so that it's dealt with, the document is dealt with at that point. The moment you don't object to it at that point, because case management is an interactive management of the case. The moment that that party misses that opportunity, my Lord, to object to that document, at trial, you cannot come and say, that document actually amounts to expert report. No. I have now a problem with it.
That's why.
Yes.
The case management system is designed. That's why at case you are asked to file your witness statement before a pre-trial conference is held, so that if this document was testified to by Mr. Amupanda, objection, because he would have known that this document will be used. He did not deal with it at case management. He did not deal with it pre-trial. So Rule 28 is applicable. But where the witness statement doesn't forewarn the opponent that I'm going to use document X, how do you expect your opponent to object to document X?
That is exactly what the authority says, my Lord. The authority of this court, that is what it says. This party was ordered to remove.
You see, whether that is correct, and you see, remember, there is a common law rule, and statutory law also does not change the common law. The common law rule is a witness who wants to introduce documents must identify the documents and testify to them. If you don't include the documents in your witness statements, how do you identify them? How do you testify to them?
My Lord, under those circumstances, the common law cannot apply when there is a specific statute to it, my Lord.
So you say Rule 92 says the witness statement must not contain annexures?
According to this judgment, it says...
No, I'm asking what Rule 92 says, not what the judgment says.
Rule 92, my Lord, says, after the case management conference or at the pre-trial conference, the managing judge must order the parties on Form 20 to serve on the other party witness statement of oral evidence which the party serving the statement intends to adduced during the trial in relation to any issues or facts to be decided at the trial.
Exactly.
So Rule 92, my lord, only refers to the oral evidence. That because obviously oral evidence is not contained in any document, you can't discover oral evidence. You must put it in a witness statement and make it available to the other party, my lord.
These are very, very innovative arguments that I'm hearing today. And you see, and just to get rid of this point, I am saying, to me, this issue goes to the root of a trial and to the root of Article 12, particularly in our current content of testimony that I'm going to give. And at court, you...
The reader justice and fair trial is key and important to adjudication of any matter before court, my lord. But the report, if the rule says you need to discover and identify a document that you intend to introduce to trial, my lord, and I do that, and the same rule say any party...
Go to your pre-trial order.
I'm there, my lord. I have it.
What does I think it's paragraph under paragraph 5. Let me just quickly give me 2 minutes. What does it say?
It says the parties record that they have filed witness statements in terms of Rule 92 and will be limited to the use of witness statements so filed.
Okay.
The parties' attention is drawn to Rule 93.
Yes. Then it's paragraph 6.
The parties have indicated that they do not intend to subpoena...
Okay, 7.
The parties agree that the documents discovered by the respective parties and those that are attached to the pleadings constitute the list of exhibits intended to be introduced as evidence.
Yes. And for the purposes of?
Sorry, my lord, I didn't...
I think, isn't the paragraph, for the purposes of paragraph so, a witness statement is regarded as, is deemed to be a pleading.
I don't find that immediately, my lord. But I can't remember that either. But it says that each party must prepare its own bundle which intends to tender at the trial and upload the documents which memory stick must be provided who is assisting the presiding, intended to be introduced as evidence at the trial of this matter. My lord, but if I may answer to that, what my learned friend is referring to, if you read Rule 92, is it 7, sub 7, 28 sub 7. Once you don't object to the documents listed, it simply means that you can use it without the original and so forth. Because 28.7 says it will then be admissible, but not as the truth. So you just get past authenticity. That's the purpose of the rule. But our objection are, and mine remain, my lord, that what must I do with this 97-page affidavit, a witness, a document? Ask the court to stand down for 3 days so that I can consult. That is the whole purpose of the fairness.
Here still on the that it's unfair what is happening here. We are not having a fair trial. And in addition to what my learned friend for the first defendant said is we might, if we knew there would have been evidence on this document sought to be introduced, we might have countered by further witness statements. As my learned friend indicated earlier, the witness statements were staggered. And this sort of litigation would scupper the trial. We'll have to study. First of all, we have to know what parts of this document is relevant and going to be used as evidence in support of the plaintiff's case. And then, only then can we effectively dealt with that document. We are not required, and I think my learned friend on the analogy of motion proceedings referred to the waste management case, which was adopted in our jurisdiction, saying that if you want to use a document in motion proceedings, you can't expect your opponent to document. You're not allowed to do that. And we don't have that benefit unless we have got a witness statement for this part of my case, my lord. And if we have to stand down to do that exercise now, this is an effective way of scuppering this trial, which I, with respect, submit to your lordship, is the intention from the start, from the plaintiff's start, from the plaintiff in this case. Therefore, we persist in the request that your lordship do not admit evidence on this document. It's actually two parts, the objection.
Yes, my lord. My lord, the pre-trial, my lord, actually supports the...
Asking this question.
Yes.
Asking this question.
Yes.
Your witness statement is limited to what you read into the record.
Yes, the oral evidence. Yes.
Now, in your testimony, you don't refer to that document.
Yes.
In your testimony,
That is correct, my
you
lord.
don't refer to that document.
Yes.
How do you expect your opponents to deal with it?
My lord, it's not a requirement,
Oh,
and
okay.
it's an agreed fact that we agreed that discovered. My learned colleagues cannot give authority, any authority to support that. Once you don't refer to a document in your witness statement, that document must not be used. The authority that is only and supported by the pre-trial order, my lord, is that all discovered documents, all attached documents to pleadings constitute a list of exhibits
That may be introduced in evidence.
to be introduced as evidence.
Yes, you
And
must. How in the through
Witnesses.
by deposing to a witness statement. You have the answer. You introduce your evidence in court by a witness through a witness statement. So the documents that are contained in the witness statement and that are attached to the pleadings, and if they have been discovered, they can be admitted. I'm going to rule and we move on.
As the court
I'm ruling that the document is not contained, the document it's unfair, it's prejudicial, and I'm not allowing it.
As the court pleases.
Yes.
Mr. Amupanda, may I proceed?
Yes. Yes, will you proceed?
As the court, please. My lord, just with the ruling, my lord, I just want to understand. Does that mean that if I intended to take the witness through discovered documents by the defendants, but not referred to in their witness statement, I cannot?
No, I can't tell you what to do. There's no way I can tell you what to do.
With that ruling, my lord,
No, I'm not going to answer that
as
question.
the court pleases. In that case, my lord, that will be evidence in chief.
And we would suggest that Mr. Pels have conclude. The reason is our cross-examination will be statements of witnesses, factual statements of our witnesses, that from the witness statements of 5, 6 exercise, it might shorten my cross-examination to a material respect. And that's why we suggest that, my lord, it was your lordship's leave.
Yes, my lord. We have discussed that and I'm prepared to continue.
Yes, you can continue.
On the authority, I think, of State versus Tamba Pillai, I think that kind of, I think the Supreme Court judgment, that sequence of cross-examination, although it's in the context of a criminal case, was not permitted.
It's not permitted.
Yes, I think it's the Supreme Court judge, although in the context of a criminal case, Supreme Court
make available the authority for me.
State versus Tamba Pillai, I think, my lord. Paragraph 130, yes, State versus Tamba Pillai, that the normal order for cross-examination in which paragraph? 130.
State versus?
Tamba Pillai, I think State versus Tamba Pillai. And others, my lord. I think it's paragraph 130 of that judgment. It says that
paragraph
130, my lord.
One 130. Tinda,
Yes, my lord.
isn't that limited to cross-examination in criminal cases, the way the judgment reads?
Yes, that judgment was a criminal case judgment.
No, I'm saying what the judgment is also saying. The normal order of cross-examination in a criminal case.
Yes. Is that counsel for the accused cross-examining in their order? Those counsel for accused number 1 will start, thereafter counsel for accused number 2, and so on. The same apply when the accused or their witness testify in this case. Counsel for this is unheard of and should not have been allowed. It was done simply because he and the accused number 1 would benefit from this, as he would then know that we submit is the same. There is no reason why.
Is it correct? Remember, in criminal cases, no witness statements are filed. Witnesses testify and cross-examine in court. So what the other witness will come and testify to is not known. But in the civil proceedings, witness statements are filed. Everybody knows who will say what.
Even in criminal cases, my lord, there is witnesses give statements. Those statements are discovered to
The testimony of witnesses is reduced to witness statements
yes,
in criminal cases.
yes.
Are you sure?
Witnesses give statements. The accused
In the witness statements as required by Rule 92 in criminal
not
case.
92, my lord, but in terms of the criminal setting, there is also a way that a witness should, under oath, even under the criminal context, under oath, give a witness statement. That witness statement is discovered to the other party, to the accused person for preparation of trial, and then they come and cross-examine those witnesses who give. And the Supreme Court is saying that the exchange, like there is no explanation, real acceptable explanation, my lord, and why that principle of the Supreme Court should not apply to this civil case, my lord. The first defendant's with, counsel must start with a cross-examination.
We would submit that the authority referred to by my learned friend for the plaintiff is distinguishable. It's obviously relating to a criminal case. And as far as I remember, I wouldn't give myself out as an expert on criminal litigation, but their procedures are mostly set out in a statute, which I don't know where the sequence is prescribed, but my submission to your lordship, the point of distinction is that that order that my learned friend relies on is prescribed by a statute. Our case is completely different, my lord. If there is a sequence prescribed, and I'm not sure whether there is one, it is in a rule of this court, and we would submit that your lordship always has a discretion to control the proceedings before your lordship.
You know, I'm very reluctant to use my inherent powers, and you would know why I'm saying I'm reluctant to use it. Yeah.
And we would submit your lordship has a discretion to control the proceedings before your lordship. And even if there is a rule that your lordship, for convenience purposes, may exercise your discretion to deviate from that rule. And my lord, the convenience I've spelled out to your lordship, it might shorten the proceedings. That's why we say it's more convenient. Thank you.
My Lord, just in short answer, the issue is clearly what Mr. Justice Frank identifies, is that out of sequence, the one accused is represented by another one by separate counsel is for the one to learn what the other's version is. In criminal law, the accused, I hope, are not compelled to make witness statements beforehand, and that is the major difference.
Just to consider the objection
It deals with cross-examination.
for in criminal matters. Section
166.
166.
I haven't read it, I just saw it.
Okay, I'll look at it. Popular Jen? Yes, in this matter, the defendants, the first defendant informed court that they have agreed to change the normal sequence of cross-examination. The plaintiff objects to that agreement and cites as authority the case of Tampa Pillai versus the state. In paragraph 130 of that judgment, the court obiter states that in criminal proceedings, the ordinary sequence must be followed and it cannot be departed from. Now, I want to emphasize that the judgment specifically limits its comment to criminal matters. I've searched, I was trying to search for authority on the subject in civil matters. I could not lay my hands to any, in the short time that I had, to any civil matter dealing with the issue. But in our instance, Rule 1, Rule 1, Sub-Rule 2 reads as follows. These are the rules for the conduct of proceedings in the court and for giving effect to the provisions of Article 12, Sub-Article 1 of the Namibian Constitution. And we are all aware that Article 12, Sub-Article 1 deals with the right to a fair trial. And the overriding objective set out in Sub-Rule 3 governs the application of these rules. Sub-Rule 3 says, the overriding objective of these rules is to facilitate the resolutions of the issues, of the real issues in dispute, justly and speedily, efficiently and cost-effectively as may be practicable. My interpretation of that rule is that it grants the court at least a discretion to determine the procedures that it will adopt in the hearing of civil disputes. And the ultimate guiding line, in my view, is a question of fairness. The question that I must ask is, will the plaintiff obtain a fair hearing if cross-examination doesn't take place in the sequence in which the defendants are listed? My answer to that question is it's a no. The sequence, because the purpose of cross-examination is to try and elicit and determine the truth and the veracity of the testimony presented before court. I am therefore of the opinion that it does not matter and it would not take away from the right of a fair trial if the sequence of cross-examination is changed. And I will grant leave for the defendants to cross-examine in the sequence in which they have agreed.
Please, you, my lord. May I, my lord?
You may start.
Good day, Mr. Amupanda.
I would encourage you to speak as loud as possible because I want to hear what you are saying.
May I start, Mr. Amupanda? Can you hear me clearly?
I think so.
Thank you. Now, your witness statement says you are a political scientist, correct?
Scientist.
Yes.
Let me get to it just so I'm clear.
And your particulars of claim as well.
Where in the witness statement? I'm with it, so you can take me there.
Your particulars of claim, sorry, says the plaintiff, Job Amupanda, an adult male person currently residing. The plaintiff is an activist, and so forth, and a political scientist.
Okay, so it's not the witness statement?
Yes.
Okay, particulars of claim, where is it so that I can go to it just to verify? So that I need to see what you have.
Sorry, let me rephrase. Are you a political scientist? Not a qualified agriculturist?
No,
You are not a qualified vet.
no,
In your documents that you discovered, you do not file any documents in respect of economic issues.
the discovery bundle is there, so we could go to it so that
In
we
your
can,
witness statement, you do not deal with any economic issues.
there should be issues that I'm dealing with.
In your witness statement, you do not deal with any agriculture.
So one of them is, for example, the food, the meat that was taken from me by the regime, what has happened with confiscation, it's all, I understand agriculture broadly, not in a narrow sense.
Yes, you do not deal in your witness statement with any veterinary issues.
It's there. I'm talking about the red line.
You do not deal in your witness statement with any job destruction which will occur if the red line is removed or the fence is removed.
Rephrase the questions again. You are too fast. So
In your witness statement, you are not dealing with any job losses which will occur if the fence is removed.
no,
You have filed a 3-page witness. How much is it? How many?
you have it with you, I guess. That the one that I have is not definitely not 3 pages.
How many pages is yours?
Want me to count it?
Yes.
1, 2, 3, 4, 5 pages.
5 pages. Sorry
6
for the
pages.
sorry for the 3. In those 3 pages, you do not refer to any pleading filed of record.
What do you mean?
You don't refer to the particulars of claim, to the pleas filed by the defendant or any defendants or anything.
Usually issues that are of legal nature are dealt with by my legal practitioner. I do not expect to ventilate every particular questions of law.
The court bundle consists of 1,762 pages. How many of those pages did you read?
How many of what?
Of the 1,762 pages of the court bundle, did you read?
Well, I read. I don't read and start counting. So I read various documents and questions of law, as I've indicated, they are dealt with by my legal practitioners.
Did you read the witness statements filed by the defendants?
Yeah, I read several, yes.
Several of them. Did you read the trial bundle consisting of 6,837 pages?
The same answer that I gave to the first one.
What is the same answer?
That I read what I read, but questions of law are dealt with by my legal practitioners.
Are you hearing what you're saying? I read what I read.
No, that's not what I said. That's what you heard.
Yes. What did you say?
You want me to repeat it again? Do you want me to repeat it again?
Please.
This is question 1 or question 2?
Question 1.
Okay. So the question 1 that you had previously asked with regards to the 1,000 pages. Okay, so you want me to repeat it again?
Yes. What did you read about that?
Can I answer?
Yes.
Yes. I indicated that I've read the documents and questions of law. I left it to my legal practitioners.
So in your estimate, how many of those pages did you read?
Well, the defendant, I understand that I'm the one who's bringing the case. They are responding to my case. I'm not a lawyer, but I'm explaining how I understand. They are responding to my case. And how you are asking in terms of what is my understanding is to defend the status quo. They are defending the status quo. They are defending the settlers' interest. They are defending the continuity of the suffering of our people. They want to keep the status quo because it benefits the capitalist interest that funds the defendants and everybody else.
What are the facts, not labels like capitalist and so forth? What are the facts that you saw in defense of the defendant's case?
I mean,
Broad, what are the facts? Can you say which defendant? Is it the 8th defendant, the 5th defendant? Or if my learned colleague want to refer to a specific fact, at least to give the witness an opportunity to do so. Just to say what are the facts that are defendants saying is too broad and unfair to the witness.
My Lord, the question is perfectly...
What was the question?
Say, what are the facts in general put up by the defendants to your claim?
my Lord, am I allowed to inquire before or I'm just obligated to respond?
If you seek clarity, you are allowed to seek clarity.
Okay. For example, I understand I'm here to assist the court and I'm providing specific answers. Is it permissible for a counsel to say, I want you to say this and don't say that? If, for instance, the core of this case is capitalist interest in the economic question. So if my response is the capitalist interest that has been protected and I'm being told that I must answer, don't say labels of capitalism. So I need advice from court that if that's what can happen.
Unfortunately, I can't advise.
Also,
No.
because I'm being told, I don't know.
You say you want advice from me.
So that I don't go out
No.
of the way.
There are questions.
Okay.
I don't advise people, whether you are a witness or a legal practitioner. I don't advise. And all that I want, what I am going to say is this. I'm a trier of fact. I am a trier of fact. I listen to evidence that is placed before me, extract from those evidence facts which will lead me to a specific decision. That's all I can say.
Did you read, can you recall any expert's name?
I know there was an objection to that, to the questions. What are
I
the
made a
facts?
ruling. I said, what is the question?
Yes.
Yes, and he asked the question. He's asking the question.
Okay.
Yes.
Can you give me one fact that is put up by any of the defendants in opposition to your claim? Only one fact.
So obviously for me to be able to answer that, you are asking what is the response to my case and you are
Yes.
limiting me to one.
Yes, and I'm talking fact.
Can I finish? So I must be able to determine so that we are together. What is it I understand as my case to which they are responding to? Can I do that?
No, I'm not asking you about your case, sir. You've already testified about your case. I'm asking you, can you give me one fact that is mentioned by any of the defendants' expert in opposition to your claim? One fact.
With regards to?
It seems to me that we can go ahead. Do you dispute that if the cordon fence is removed, 33,271 permanent jobs will be lost?
Yes, I dispute.
On what basis?
On several bases. Yes. One of those bases is that the government of the Republic of Namibia commissioned a study. And that study was meant to understand what will be the consequences of the total removal of this colonial 1896 of the regime itself. Is that we know it's common cause that agriculture's contribution to the GDP is 6%. The government found, number one, that the removal of the red line of this colonial instrument would lead to the increase of agriculture's contribution to GDP from, actually in the report it says 5.1% to 20% of the country's GDP. It also indicated actually in numbers how many jobs will be created,
Okay.
both nationally and also what will happen to that area of people who have been
So
discriminated
you
and kept out
dispute,
for 125 years.
you
Is the
dispute
answer?
the evidence that 33,271 permanent jobs will be lost.
Yes.
Thank you. You are also employed or work at the University of Namibia.
Yes.
Did you ask any of your colleagues there to assist you to file a witness statement on the economy of this issue?
I'm in court to vindicate my rights and how I would proceed with my case. I came to court to indicate to court that in 1896 a colonial instrument has been put in place. That colonial instrument stayed on through the German colonialism, South African colonialism, and it continues. In my view, it violates rights, and I'm coming to court to vindicate those rights.
Yes,
and those rights are not dependent on what anybody else think, because we are living in a constitutional dispensation. I didn't find it necessary
Yes.
to be able to do that.
That's
Where
wonderful.
I found it necessary, my legal practitioner and I had composed a list of witnesses to be in necessary documents that were submitted in discovery to be able to advance that case. So it is, to my mind, the case that I'm bringing to court, not what you or your client think I must conduct the case.
Yes. So you agree, so you did not, the question is answered as follows. You didn't think it necessary and therefore you didn't ask any of your colleagues to assist you with testimony.
Because I'm very clear in terms of my case,
Yes.
what it is about.
Thank you. And that also goes for any health science and veterinary medicine. You didn't think it necessary or to ask anyone to assist you.
So, when, for instance, when I read these documents of your clients and the clients of the regime and everybody else, they seem to think this case is just about meat and animals. Yeah?
What is, sorry, yeah?
They think this is all about meat and animals and what they are going to lose and what they are exporting to Chinese and Europeans. At the core of this case is also dignity. It's about continuity of colonialism. It's about a colonial instrument that the Minister of Agriculture says that it is the most, he speaks about the book that writes about this history, that it is a comprehensive historic record of one of the most pivotal tools of division in colonial Namibia. So it is about dignity. It's about continuity of colonialism that is protected by the regime and other stooges of the regime that continue to discriminate 60% of the population. So it's not just about meat and Chinese and what Europeans are going to lose when the colonial instrument is removed.
Look, sir, I cannot stop you to say things over and over and over, but we've heard that. So please try it. So you say that you haven't asked any colleague at the university in any department to assist you because you don't think it's necessary.
What is the question?
Well, I've asked it just now. Expert evidence to this court to assist you in your case. You say it's not necessary.
I understand what my case is, and that's why I'm called to ventilate my rights, not necessarily on what other people think.
Yes, thank you. Can you go to page 15 of the court bundle and your particulars of claim?
Page?
15 of the court bundle.
Can you assist me?
In which volume, in which file?
Well, that was volume 1.
Where is volume 1?
And that is, I want to refer you to your prayers.
Yeah, my question is, which one is
No, that Amupanda. Remember, at the beginning, I asked the question, has your legal practitioner prepared and numbered the files for you? And the answer was in the affirmative.
Yes.
So you don't ask me in court now, which way is that? Because I asked that question earlier. Has your legal practitioners numbered the bundles? Have they provided you with the bundles? And the answer was in the affirmative.
As well. If I may hand to your lordship this bundle, I'll make it a separate annexer.
The particulars
No,
of claim?
let me help you because you.
I have it here with me.
I'm trying to help you, Mr. Amupanda.
I'm saying I have it here, my lord.
Please look at, okay, if you want to, look at page 15. That your lordship will find in that bundle which I've now handed, it's the third last page. That bundle is numbered 138 at the right hand foot of the page, and I'm at page 136, which is 15 on the right hand top of the court bundle. Are you there? Are you at page 15, Mr. Amupanda?
Yes.
Is your lordship with me?
Is that the notice of exception?
Yes, wherefore the plaintiff prays for an order in the following terms. That is, his prayers in the particulars of claim. My lord, the bundle which I've now handed to your lordship,
Yeah.
that 6, which is the third or fourth last document in the court bundle 15. So that I put us to this court. Are you with me, Mr. Amupanda?
Yes.
Now let's just look at your prayer. An order, is your lordship now with me? An order declaring that the erection of the veterinary cordon fence has not been carried out in terms of any law. You see that?
Yes.
That's not true.
It is my case that it is true, it is so.
Did you look at the following? Section 16(1) of the Animal Diseases and Parasites Act 13 of 1956.
And that is where you and the regime and your clients get it wrong. When we are talking about the red line, it exists at 2 levels. At the conceptual level and also at the level of reality. It is accepted here in this document, in the pre-trial. You and the regime and everyone has...
Those colonial racists had a power in terms of an act to erect.
Materials for your lordship to decide.
Lord, it will be, for my learned colleague to object to the witness's testimony, especially in light of this arrangement that has been done in changing of cross-examination, my lord, that in case.
So we are, can I just try and just focus, please? You can answer.
No, there were many interruptions.
I'm busy with
Yes.
prayer 1, in which you want this court to declare that the fence, prior to when it was erected, was not done in terms of any legislation.
Yes.
Now, I'm saying to you it was
Absolutely.
legislation.
Now, in the late 1800s, in the late 1880s, the disease called rinderpest was discovered in East Africa and started moving towards Southern Africa. Right? In 1896, the report started coming.
Germans now.
The colonial decided that they need to protect the European head. What is called the Freiburg Conference. And the Freiburg Conference was pondering with these questions: what do we do in response to the rinderpest disease? And they took quite a number of resolutions. What is it that they need to be able to do? They said all these countries, the German South African government also attended in Botswana. They took 5 resolutions. One of those resolutions is that they need to make sure they stop the movement of animals across the borders of all those member states or countries that were present there. They also decided they need to impose a strict control of the Africans. Yeah, so that's one of those resolutions. Every other country went then to go and implement. Theodore Roodveen, who was the governor of German Southwest Africa, had a problem because by then they probably the colonial government fence that red line to be able to protect the European head. They didn't do it because of any legislation. nor to physically monitor the construction of that fence from November 1896.
Are you putting facts before court, or what is it?
Well, I'm a scholar, I'm a political scientist, so I read this, I understand this.
I remember what I said to you. I'm a trier of facts. I'm a trier of facts. I am not trying history. I want facts. Okay, and so when you are putting statements to me, it must be either evidence which you can substantiate.
Look.
You see, what I need, as I'm saying, I need facts that will assist me to determine the dispute between the parties.
My lord, but that is exactly, I'm trying to ask a question, but if it's obvious what he decided, whatever so I'm going to go, can I just...
Yes?
Yeah, so you indicated, because I was answering the question and your intervention came, and I don't know what to do with...
no, I asked, you see...
Yes, I didn't get an opportunity to respond.
I'm asking you the question. Yes. You are talking of what Lindequist did.
Yes.
You are talking of who went where.
Yes.
So I'm just... and I want to guide you. Well, that's why I asked the question. Are you talking about factual issues that you are aware of? Are you giving me a lecture?
That details the history of this 1896.
Who gave me a book?
No, I'm saying my legal practitioner in the opening statement yesterday, he referred to you. He referred you to a book.
Yes.
I was listening carefully when he was doing that. So you indicated, am I giving facts? I'm indicating to you that this is what I've seen, even in terms of the book that has been referred to my legal practitioner to court. Those historical events are there, even in terms of that text that has been brought to the attention of the court. So those are facts, Your Worship.
Okay. Did you...
It's opportune time to break. I see it's past 1 now. Perhaps it's opportune to break now.
Okay, I see it's 10 minutes after 1. We will break for lunch. Amupanda, when is university starting?
The administrators are already there.
Sorry?
The administrators are there, so university is open.
So when are you preparing for lectures?
Lecture starts in February.
It's just around the corner. Yes. Now, you can speak to anybody about your preparations of lectures, how many students you will have, about the rain in the north, the non-rain in the east. You can speak to anybody about anything. But you are not allowed to speak to anybody, including Mr. Kavila, including Mr. Ntinda, on the subject matter that is before court now, whilst you are under cross-examination. Do you understand?
Yeah.
All right. I don't know. You are not allowed
to Facebook.
You are allowed to speak to. You are allowed to speak to nobody about this matter. Whether you are posting, whether you are addressing under cross-examination. Yes.
Thank you, my lord.
Court will rise, and we will resume at 2:30.